Hi, I'm Scott, and I'd like to welcome you back to part 2 of 2 of the My LD Coach Plea Bargaining Topic Lecture on the September-October 2025 LD topic on plea bargaining. A reminder, part 1 was already released. It goes over the history and background of plea bargaining. This is part 2, which is going to go over all of the different debate arguments that you can employ on this topic. Hope you enjoy! Before I go off on this topic, I want to give you a brief little preview of all of the different debate arguments, different styles that encompass this video, because I want to remind you, via the power of YouTube, you can click on any of these in the description box below and go to that automatically. If you only want to read critique arguments, you can go there right now and just click on that link. I highly recommend that you watch this whole video in addition to part 1 that goes over the definitions, the background, the history, the 101 behind the criminal justice system and plea bargaining, because oftentimes I'll get an idea from one of those parts that ends up shaping how I think about the topic and the different arguments that I say on the topic. But if you want to jump right into different counterplans or different philosophy arguments, you can do that right now. Before we get into all of these different arguments, I also want to remind you that the exact wording of our topic is resolved in the United States criminal justice system. Plea bargaining is just. We had a topic that was very similar to this in 2018 in January and February that was resolved. Plea bargaining ought to be abolished in the United States criminal justice system. I say this because of a couple of reasons. One is that the topic is almost the same, except the sides are flipped. Whereas in the current topic, you would probably say that abolition would be a negative argument rather than an affirmative argument. So if you were to go to the wiki and look at all of the different arguments that teams said on this topic, which you definitely can, just remember the sides are probably flipped. The arguments are a little different. There's a lot more debates about the word abolish and how that works, but definitely a key resource and place that you could start as a starting point on this topic. The second place that I would definitely go to is the 2020-2021 policy debate topic. While plea bargaining was a little bit about that topic, there's a couple of camp files on that topic. There's a lot of files, especially on the Open Evidence Project, that speak to just criminal justice reform as a whole, and I think that a lot of teams will use this as a resource to establish a base layer of arguments that they might say on the topic. We've had a couple of criminal justice reform topics in LD in the past, like this rehabilitation topic that we had last year, but none of them have been quite exactly this plea bargaining topic. So I think that this will be a very helpful resource for you to start before we get into all of the arguments. Speaking of which, let's talk about values, criterions, and philosophical arguments now. Before I get into any specific values, criterions, or philosophical concepts, I want to stop off and give a couple brief thoughts about this style of argumentation on this topic. The first thought that I have is that this style of debate is definitely back on this topic. This definitely seems like a topic that is a value topic rather than a policy topic, and even if you have only said policy arguments in the past and want to continue to do that, I think it's inevitable that you are going to have to confront philosophy-style value criterion cases and arguments on this topic, and that it behooves you to invest time in this style of debate, at least figuring out how you're going to answer philosophy-based cases within that scope of the topic. Because I think that, secondly, the wording of the topic, with the topic saying is just, really lends itself more to justice cases rather than cases about morality. We've seen a lot of morality cases over the past couple of years that have been based in utilitarianism. I think that a lot of people will probably not say util as much. I'll get into that a little later, but I don't think that this topic lends itself as well to the util justifications that we have had in the past. And I think that that opens this up to be a very good philosophy topic. The next thing that I have is that a lot of this topic, especially from the value criterion perspective, is bidirectional. The same philosophical concepts will both affirm and negate. There will be ideas for the affirmative and the negative. The warrants behind them will just change. And I think that, I will even catch myself while I go through this saying arguments for one side when I should be saying it for the other, because really, based on how you word things, based on how you view the world, it could change from being affirmative to negative really fast, depending on how you specifically choose to say that argument in a debate. The last thing that I want to say about these value criterion cases is a lot of these cases are going to rely on the hypothetical, whether or not plea bargaining is just in a hypothetical reality, in a universal world, rather than in the real world, how this is actually working. And I think that tackling both of these head on is a really smart way to make your philosophy case a lot better in this debate. So, value criterion cases, there's some general tips. Now I'm going to get into some specifics, starting, I can't help myself, with Kant. While I'm definitely not an expert in how debate utilizes Kant, because my interactions with Kant have always come in history in the academic realm rather than from how debate value criterion cases use Kant, I really think that Kant is going to be a really good value criterion philosophy case argument that you can use on this topic. I think that it will be used on both sides of this topic. I think that this is for a number of reasons. The first is what I just talked about in terms of an ideal world versus the real world. I think that in an ideal world where the world operates under a universal set of principles, that Kant would probably affirm on this topic. However, if we look at the reality of the situation, it would probably negate. So I think that this leads us to a healthy debate, and it's probably been why a lot of debaters have been arguing whether or not this affirms or negates, and I have the secret tech on why it negates and all of this. I think that that's not true, and that this could definitely be two sides of the topic. I think that Kant starts with the idea that sort of crime cannot go unpunished, but that punishment must be done in an objective manner for everybody in a universal principle, rather than being subjective for certain individuals and for certain individuals to get better treatment or more fair treatment than others. I also think that there's an aspect to this where certain teams will argue that cruel punishment should not be given as a part of affirming Kant or negating Kant. I think that the categorical imperative is a really good example for this. So if plea bargaining operated off of a universal set of rules, I don't think that it does, that this would treat individuals as an ends in themselves, which would uphold the categorical imperative. So in this hypothetical realm, this could affirm, whereas in the real world, plea bargaining probably doesn't operate under a universal set of rules and changes and is a dynamic process, and rather treats individuals as a means to an efficient system, especially, which we'll get to later, if, the affirmative says these court clog style cases. I think that a negative team that uses Kant would be really successful against these style of arguments in the debate. I also think that Kantian concepts of autonomy are going to be brought into these debates, where people have the freedom to make their own choices, that plea bargain as a concept is voluntary, it's non-coercive. Even if you say it's coercive, maybe we'll read some definitions that say it's not supposed to be, therefore you can't think about it that way. And I think that if plea bargaining were to be voluntary, it were to be non-coercive, that would definitely uphold the autonomy of the individual defendant to make their own decision for whatever they would like to do. So I think that Kant is definitely a good philosophy argument to make on this topic, and I think that you could say it for a number of reasons. And I also think that you could say autonomy for other reasons, which I'll get into now. I think a general autonomy value criterion would also work on this topic. I think just like the categorical imperative, we're seeing a trend here, probably means we have a healthy topic to debate, that autonomy could be either an affirmative or a negative argument in this debate. So I think that the affirmative would say the defendant has the right to choose their fate. They could choose trial, or they could choose to take the plea bargain. There's all sorts of other reasons. Maybe the defendant wants to avoid the trauma behind the public trial, and and that affirms their autonomy. There's all sorts of reasons why this could be a thing. But the negative could also say autonomy. It could say that the victims don't have the right to confront this person in court. So the Brian Koberger example that I gave in part 1, a lot of the victims' families said that they don't have autonomy in plea bargaining because they do not have the ability to seek justice for their family members who were murdered. I think that there's other angles to this where plea bargaining, if it's coercive in nature, does not have autonomy or does not give the defendant autonomy because it coerces them out of having that individuality. I think that, there's definitely affirmative answers to this, as I went over in the affirmative section. Maybe that public trial actually causes those victims' families more harms that they didn't anticipate, or that it avoids that trauma. So I think that this is a healthy subject for discussion. I also think that the concept of justice as fairness as a value is potential on this topic. I think that it's going to look very similar to what I talked about on autonomy for Kant, where the affirmative is going to say if plea bargaining is informed, if the defendant knows all of the aspects to it, there's nothing shady going down, it's voluntary, it's transparent, everybody's involved, and there's no coercion, that would likely uphold procedural justice and fairness, and that the concept of plea bargaining is meant to do this. Although I guess you could use different court cases like the Hayes decision to say that, maybe coercion is a part of this process and it actually is the opposite, and that plea bargaining is inherently coercive and therefore does not lead people to voluntary decisions, does not uphold procedural justice, does not have access to the courtroom or a jury trial or due process, or all of these different aspects that agreeing to a plea bargain sort of forces upon the defendant. So while I think there's a case for the affirmative, I think in reality there might be a better idea behind a negative case on justice as fairness for this topic. So I think there's a lot of healthy value criterion topics for autonomy, for justice on this topic. I think egalitarianism is another philosophical concept that a lot of teams might employ in value criterion style cases. I think that a lot of these teams will probably use Rawls as their author and say that Rawls's theory of justice says that society must be fair and equal for everybody. Therefore, all defendants should have equal access to things regardless of wealth, race, etc., and that there should be a mechanism to resolve these cases quickly and fairly. I think that the affirmative will likely employ not only Rawls's theory of justice, but probably the veil of ignorance as well, where plea bargaining will avoid sort of harsher sentences and prolonged detention, and that if we looked at that from the veil of ignorance, that of course, somebody would want to avoid a harsher punishment or prolonged detention, regardless of the situation that they were in. So that would probably uphold that. And it would probably support the concept of fair procedural justice being administered on both sides. Now, the flip side of that is that, the jury, the judge are a key component of that procedural justice in the court system. And that if plea bargaining is just, then it can't be just because it's unfair. And I think that negatives will also utilize this concept, especially when cross-applying kind of how the real world utilizes this to say, actually, how plea bargaining is deployed in the real world does not uphold the veil of ignorance because wealthy people or white-collar criminals are given much better deals than people who are minorities who face drug crimes. And I think that this will be a lot of strong negative ground on the topic. I also think that teams will say libertarianism on this topic. Typically, if Rawls is good, the flip side of that is going to be Nozick, where people say that plea bargaining is just going to allow people to freely choose whatever they want to do and that they should be able to do that. Now, just like we've been saying, how every single one of these both has affirmative arguments and negative arguments, I think that there's really good negative arguments for Nozick on this topic that just says that the way that plea bargaining works is a mechanism of the coercive state, and that it imposes its own sentences, its own rules, and has these prosecutors threaten things and not have all of the arms of justice involved, and doesn't allow you to choose and only gives you 15 minutes to accept or deny the plea bargain. And I think that there's a lot of really healthy arguments here to be said for libertarianism on this topic that would be a really strategic place to go if you want to go that route. I also think that there are a couple concepts of justice that can be employed on this topic to great strategic benefit. I think the first one is distributive justice. I think that the idea behind this would be that the affirmative divides up scarce resources in the court's time, the defendant's time, the government's money, different personnel ideas, to most efficiently handle all of these cases, and directs those resources to go to the most severe crimes or to the places that they think is best well suited for this. I think that this might be a place where a lot of policy debaters or a lot of util debaters get a lot of their ideas for not util cases, because I think the concept of distributive justice would probably go hand in hand with a lot of these court clog style contentions that I think a lot of teams will say on the affirmative on this topic. So wouldn't surprise me if those two things are combined together. On the negative, I think that there's the flip side of this could be true, where I said there's disparities between how different sentences are given out, different socioeconomic barriers, legal disparities between wealth, race, gender, etc., and that could be the negatives ground on this topic and might go hand in hand with a lot of negative contentions that are really strategic on this topic. I think that affirmatives might even try to combat this by reforming or standardizing plea bargaining. I'm not sure this is topical or a part of the topic. I don't think that's going to stop affirmatives from trying to do that, but I do think it's going to be a reason why distributive justice is going to be one concept of justice that is going to be good as a philosophy style argument. Another concept of justice that I think teams will employ is the idea of retributive justice. That is the idea that the punishment should fit the crime. There is a theory called just deserts theory that says just that, and retributive theory of justice operates behind that ideal that the punishment should fit the crime for whatever crime was committed. A lot of people would say that this is probably in conflict with plea bargaining, because plea bargaining reduces those sentences to no longer fit the crime, right? In the case of Brian Kohberger, he was faced with the death penalty because he committed murder. Maybe that fit the crime, and since he's plea bargained down to life without parole, that lowers the punishment and no longer fits the seriousness level of the crime that was committed. And there is a lot of scholarly evidence that says that plea bargaining violates this idea of retributive justice because it decreases sentences to make it so that it does not fit the crime. Now, the flip side of this, I'm getting tired of saying this almost, could also be true where maybe that's a good thing. Maybe the affirmative can utilize this to say it shouldn't always fit the crime, and that is a good thing, which we'll get into now with restorative justice. The idea behind restorative justice is that, sure, somebody should be punished for the crime that they committed, but they should be restored back into society and helped. They should be rehabilitated, whereas retributive justice says that they should be punished first rather than restored to society. So the concept of getting rid of plea bargaining would probably increase retributive justice, because those people who committed crimes would be forced to serve the severity of the punishment that they faced, which would mean that the punishment would fit the crime. Restorative justice, which a lot of European justice systems operate on, works the exact opposite of that, where sure, you should be punished, but we should give you some benefits to try to help you maybe not do that thing in the future. And I think that a lot of concepts of justice use this concept of restorative justice to their benefit, to say that the way we treat criminals now is more of a retributive way, and that in order to make society function better, to make sure that, you know, people don't go back to prison, there's not a high recidivism rate, that we need to instead focus on how we help people who have committed crimes rather than punishing them. For instance, virtue ethics would say that the way which we treat criminals now is a bad way to treat criminals, because we need to focus more on the character and morals behind the decisions that are made. And I think that there's some really good ideas here for why restorative justice could be an idea behind upholding plea bargaining, because it would reduce sentences to allow people to reintegrate into society faster. Next, social contract theory. Not going to talk a lot here, because if you're interested in this, I found like 100 scholarly articles in 2 minutes researching for this, so you should just go there now. I think that this is a very healthy subject for both sides. I think that the affirmative is just going to say that in a free society, citizens should have the ability to enter into contracts if they want to at their own volition. A lot of times people will add the caveat that as long as that bargain or legal mechanism or agreement is fair. So I think that social contract theory definitely going to be big on the affirmative, but probably larger on the negative, because a lot of these contracts are entered into in a way that does not uphold social contract theory, because they're not fair and they take advantage of this system. And I think that a lot of negative teams will definitely go that route in the debate. I think that a combo that teams might think here, but probably its own thing, is that ideal theory would be a way to conceptualize this for the affirmative to try to avoid some of the negative ground with how social contract theory works, because all of those social contract theory negative arguments are going to rely on how those concepts work in reality, in the real world, and how the world actually is, rather than how it ideally should be. So I think going back to what I started with when I started this whole section of the hypothetical versus the real, I think teams that want to talk about the hypothetical will probably use ideal theory spliced in with a couple of these different concepts to try to get some ground back in the debate, especially if they're trying to say the affirmative side on this topic. Finally, utilitarianism, the concept that the greatest good should be done for the greatest number of people. I think that teams are going to say util regardless of the topic, because certain teams just want to say that regardless of what the topic is. I probably think that this should not be as prevalent on this topic, because util screams more of a moral issue rather than an issue of justice. However, I think that teams will say this regardless. There's probably a couple of good reasons why. The first one would be is that it just maximizes utility. The court clog scenario that I'm going to talk about, for instance, in a second. The trial costs would be reduced. The courts wouldn't be overwhelmed. There would be benefits for society as a whole that would be gained via plea bargaining being just. The second concept would be that it decreases suffering, because that trial that happens may lead to victimizations, may lead to people having to testify in court, that causes suffering, and that util and plea bargaining being just avoids that and does the greatest good for the greatest number of people. Now, I think that there's kind of a problematic rationale behind util on this topic that teams are going to have to deal with. And that is that for the past couple of years, especially for the TOC mattering topics, a lot of the topics have said the United States ought to do something. And that topic structure relies on the government being the moral actor in the debate and lends itself to, in society, the government should maximize what's best for its citizens, which really lends itself to util. I think that this topic is very different and is grounded in justice, and is not about justice for the government, but rather about individuals, and that is going to massively change the justifications that util teams are going to face when trying to justify why util should be a concept that should be used in the debate. Now I'm going to talk about the affirmative and negative sides, but before I get into that, I want to talk a little bit more about util style cases, policy debate, and sort of give some tips for some policy debate style LD debaters going into this topic. A couple of thoughts before we get into specific Aff and Neg arguments on this topic. I think that LDers that have a style that is similar to policy debate are going to notice a couple things that make this topic a little different, a little harder on you. The first thing is that the affirmative just doesn't have inherency. The topic pretty much describes the status quo. If the resolution said is unjust, then that would be a departure from the status quo. So if you look at when I started the video, I talked about how in 2018, I believe, in January and February, we had a plea bargaining topic that said abolish plea bargaining. If that were the topic, then this wouldn't be an issue because that would be changing the world. The consequence of this is that if we look at that topic, the sides are going to be flipped. So the affirmative is going to say the world now is okay. The negative is going to say we need to change the world. Changing the world is a good idea. I think that this probably definitely flips the sides, but it probably also changes how presumption works in the debate because the negative team would be the team of change and the departure from the status quo. But I think more so you're going to see a lot of teams, especially the policy debate style teams, try to read like disads as advantages, maybe the politics disad as an advantage. And I think it's going to get really convoluted for a lot of teams, and I would hesitate towards doing some of that. I think the second thing is that the affirmative team probably just has to defend the status quo. I think a lot of affirmative teams are going to try to say reform plea bargaining to something that it's not now, and that is just. I'm not sure how that upholds the word is. I'm also just not sure that upholds the phrasing of the topic. So I think that the affirmative is going to be very limited on this topic in what it can do. I think that the saving grace on this topic for a lot of these policy style arguments is that if you're willing to say the USFG is not going to do these things, that you can use that to your benefit. The resolution at no point says that plea bargaining has to work or has to be abolished or has to fiat anything done or you have to solve anything. There's actually even no actor in this resolution at all. It's probably more an individual statement of justice. So I would be hesitant towards fiating changing the world or reading solvency cards, and I would think as the affirmative, how do I answer those arguments in a world where we are just upholding a statement of justice rather than having a government-issued morality statement about what we should do in the debate? So as we go through these different affirmative and negative arguments, you should be thinking, this is a disad, but it's an aff advantage. Why is that true? Normally I'd say solvency here, but it doesn't work in that scenario. But I also think, for negative teams, maybe even for affirmative teams that try to reform, that you're going to lend yourself to a whole host of problems here that are just unnecessary. Now on to the affirmative advantages and contentions. Before I get into this, I want to note that this is not comprehensive. These are just some of the contentions I thought would be more prevalent, would be more popular on the affirmative and the negative. There's definitely going to be a lot of other arguments, so you should do your own research. But I think that arguments like the court carrying capacity advantage are going to be extremely popular. We saw this the last time plea bargaining was discussed, and I've already seen a bunch of different camps discussing the idea of court clog. The idea behind this is that every case, if plea bargaining is unjust, would have to go to court. And the reason that plea bargaining is just is that it allows the court system to not be overloaded. If plea bargaining was unjust, it would force every single case in the court system to go to a trial. This would probably lead to one of two scenarios. It would either take forever for anything to happen because every single case would have to go through the full court proceedings that we see now, or there would just be like 30-second sham trials that would make the system seem like it wasn't enacting justice at all whatsoever. There's a lot of different policy impacts and arguments behind this, but the basic idea is that we need the court system to function for democracy, the justice system, society to all work together, and that plea bargaining is a core function of how this works because it prioritizes the important cases to use the courts, and the other less severe crimes get plea bargained so that the court system cannot get overloaded. A couple of problems, warnings with this. The first one is that there's not a lot of uniqueness for this. A lot of the courts are pretty overwhelmed now. Sure, plea bargaining would be like a huge link to this, but I think that there's still just a structural issue of the courts are really still overloaded now. The second warning that I want to give you is there are different court systems. There was a topic last year that a lot of people in policy debate read court arguments on, the IP, copyright, trademark court, Aff style, Neg Disad style arguments. The problem with these arguments is that a lot of them use different court systems, different court cases. It's not criminal court. So I think that you should also be very, very, very hesitant or be very cognizant if you are making these arguments, that they need to be done properly and using the right style of courts. The second reason or second contention that I think people will say that just kind of goes along with this court clog argument is just that it's bureaucratically beneficial. Now, I know a lot of people will say, well, that lends the negative up to saying bureaucracy is bad, but I think at a just capital T truth level that plea bargaining is efficient. It allows the criminal justice system to operate in a way that allows it to work, and that we don't really know what a world would look like if plea bargaining didn't exist, because we don't have the resources to deal with that world. There's not enough judges, there's not enough space in jails. All of these systems would become overburdened, and it's really beneficial if we were able to have plea bargaining from a bureaucracy standpoint. On the flip side of this, a lot of this is focused on why it's good for the government, but it's probably also good for the person who accepts the plea bargaining. The reason behind this is the public defender's office faces these same issues, right? If every case has to go to trial, the public defender's office is going to have thousands of cases for each public defender, and there's no way that those individuals are going to be able to get the justice that they deserve. I think that another popular affirmative contention will utilize European concepts of the criminal justice system and of how Europe deals with justice when it deals with prisons, focusing on rehabilitation. There have been a couple past LD topics on this, but I think that people will say that plea bargaining allows the defendant to take responsibility. This allows for a form of restorative justice where they will change their behavior since they've been given a deal. They won't be locked up for as much time, and that will mean that they won't go back to jail because they don't want to face a consequence where they are not given a type of deal like that in the future. I think that rehabilitation will definitely be a strong affirmative contention on this topic. I think that another place that a lot of people will go is the crime disad as an advantage. I want to give a warning here to teams that I would probably look at this and make sure that you are comfortable saying the things that you are saying in this debate. I think that there's a really good scenario for an organized crime style, cartel style advantage, but I think the generic crime disadvantage seems kind of scummy, seems kind of not politically correct, racist in how it is viewed in today's society, and I would be very hesitant to saying like the carte blanche crime disad. So that's my warning to you. Now let's get into the crime disad. I think that there's a great case for why plea bargaining is just in allowing the government to deal with organized crime. It allows the government to give people deals where they will give up their sources, they'll give up their partners, they'll snitch, they will rat out in order to not face jail at all, to have more lenient charges. Remember, plea bargaining isn't just reducing your sentence. You could just go straight to probation. You could avoid prison altogether. And I think that affirmative teams will utilize this when making organized crime arguments, white-collar crime arguments, drug crime arguments on the affirmative, and might even combine some of these with ideas of restorative justice, with rehabilitation, to package that into something that is more strategic in the debate. I think another contention that will be very popular are different styles of the victimization contention, whether it be the victims, the family, the defendant. I think that the concept of avoiding trial means that people will not have to face the consequences that come with that. For instance, there's a lot of evidence that trials are really devastating in instances of sexual assault. So I think that this could be a scenario where the affirmative could use a victimization contention to say that those facts don't have to be publicly acknowledged, don't have to be stigmatized by the media, don't have to be publicly held in this open trial, and that plea bargaining is just in doing that. There's the flip side of that as well, where, you don't get to face the person who committed these crimes. There's a lot of family victimization debate happening with Bryan Kohberger, where the affirmative side will likely say that it is just because the family didn't have to relive that terrible experience, see all of the pictures and evidence. But on the flip side of that, the family has said that they need that justice, they need to see that, and they need to see that conviction and the full extent to it upheld in order for them to feel like they have gotten justice. So I think that while this is an affirmative argument, definitely something that can be said on both sides of the topic. However, I also think that there's a good contention that's just like it allows people to get on with their lives. I think that a lot of this has to deal with more minor crimes in the sense that, people face multiple years in prison, or they're going to face probation. A lot of people will take a plea deal in that scenario in order to get on with their life. If you are a parent, you don't have the ability, you don't have the time to just wait in jail for your case to be heard. You want to get out and plea bargain so that you can deal with your family commitments, your job, all sorts of different aspects that make it so that people just want to not have to deal with the long drawn out court system process that takes an incredible time to deal with. Now, the flip side of this is also true and has a lot of really good arguments. Maybe it's good to draw out people's lives, there's a lot of different value criterion, justice arguments that could be had here too. So I think that this is one other aspect of the topic that affirmative teams could go to when looking for different contentions. I think that the economy contention is just kind of inescapable in debate. I don't think it has the best warrants on this topic, but there's a bunch of different angles you could approach it. It'll probably be similar to the court clog disad and this, or disad as an advantage, where you save the taxpayer money, the courts are more efficient, things like that. I also think that the affirmative could read different constitutionality arguments, whether it be rule of law, separation of powers. I also think the negative could probably say these as well. I think that you'll also see a lot of teams try to read disadvantages as affirmatives. So I think you might see the politics disad as an advantage. I really never think that this is strategic, but I don't think that that will stop people. I think people will say that criminal justice reform is super unpopular, causes a political firestorm, causes politicians, Republicans that are all in charge, the president, to all sort of be up in arms and cause a political firestorm over this. I think something that might be way more strategic would be kind of the court politics disad as an advantage. I'm not sure how this works with the current composition of the court, but I think that, maybe this has a legitimacy angle, some sort of trades off with different other cases that the court is going to see. I think that the court politics disad as an advantage on this topic could actually be something that is incredibly strategic, especially if you want to say util style arguments on this topic. The last major affirmative contention that I want to talk about is the death penalty. I know I've been talking about Bryan Kohberger a lot. I think it's inevitable given, one, it's the most prevalent plea bargaining case in the news right now, but two, it gives us a great example of the death penalty, that plea bargaining allows defendants to avoid the death penalty, and that in a lot of situations, when faced with the death penalty, defendants will insta plea bargain because they do not want to die. And the reason that that is just is that even in a past instance where somebody has committed murder, a lot of people do not believe in the retributive justice idea of an eye for an eye, or whatever analogy you want to use. So therefore, death as a punishment is unjust. Now, just like every argument on this topic, there's the flip side of this, where plea bargains are just used coercively to incentivize deals. There's an entire book about this, or article, I forget which, called Leveraging Death, that entirely goes in the other direction. But there is a plethora of different sources about how the death penalty is used in plea bargaining, and I think that a lot of teams will go down this route. I also think that you could see some more critical affirmatives that use this contention, because the state offering those plea bargains gives it the ability to control who lives and who dies, who isn't offered a plea bargain. So I think that affirmative teams will definitely go down that route as well on this topic. I want to stop off very briefly and talk about planned affirmatives. I don't think that these affirmatives are going to be that strategic or popular on this topic, nor does this topic really lend itself to a lot of plans, but I think that there's maybe a couple places that people will go. I think that the first one is that teams will try to specify a specific instance or a specific way that plea bargaining is just, a specific charge, a specific sentencing guideline, a specific circumstance. I also think that a different version of this would say that plea bargaining is just in a specific jurisdiction, in federal courts, in a specific state, in specific localities, just by the nature of how planned debate works. I think that some people will try to go down that route. I think that the most strategic way to probably do that I have seen in the past, is have some style of courts affirmative, kind of what I just talked about with the court legitimacy contention. I really think that a court style affirmative that utilizes the minutia behind how the court works now, different decisions that are coming, etc., could be a really strategic way for a planned affirmative to work on this topic. I, however, do not think that it's going to be strategic for you to say, like, reform plea bargaining, regulate plea bargaining. I think that some teams are going to do this. I'm not sure it's strategic. I'm not sure that that's where you want to be. I don't think it's strategic from a policy perspective. I also am not sure that it's topical, but I do think that this is a aspect of planned affirmatives that people will say and that you have to be ready for. I do think that there may be more prevalent cases of different styles of pleas. So for instance, there's the concept of an Alford plea, where you plead guilty while maintaining your innocence. So you do not admit guilt in the aspect of the plea bargain. The reason that this is kind of a take it but leave it scenario is there's not a lot of them, so you can't get that much leverage as the affirmative, but it doesn't link to that much stuff for the negative, so you kind of got to pick or choose what you want to do here. There's also the concept of no contest plea bargaining, conditional plea bargaining, all sorts of different things like this that people might go down the route of, but again, I really don't think that this is going to be as prevalent or strategic on this topic, because it really just doesn't lend itself to this style of debate. So now let's switch side debate, and go to the negative. I think that the most basic negative contention on this topic is just that plea bargaining is coercive. It forces people into guilty pleas, and it forces innocent people to agree to become guilty. I think that this would be because the defendants are overburdened for a host of reasons, a lot of it probably having to deal with once they are arrested, they are in pretrial lockup, can't get out because of the nature of the cash bail and bond system in the United States. They have a bunch of charges stacked against them, and they just want to get out of jail. And I think that that nature is how a lot of people coercively agree to plea bargain agreements. There's also instances where the prosecution will threaten different family members if that doesn't happen, or they'll charge different family members. So I think that there's a lot of instances that coercion could be a really good argument on this topic. The second argument that I think will be read on this topic is mass incarceration. Tons of evidence on this that's just plea bargaining is the way that the criminal justice system, the way that prisons are sustained in the United States, the prison industrial complex operates off of plea bargains because it puts people behind bars. Now, I think that the affirmative is probably going to say the alternatives to this are worse because it just makes everybody go to a jury trial and get locked up for longer, but I think that the negative has a lot of ground here in the plea bargaining system really just sustaining this evil prison system that is super predatory upon people, and even once you get out, that this probation system, even if you don't go to prison and you just get probation, sets you up to fail in the future, sets you up for prison in the future, and is an entirely predatory system that is unjust. The third contention, and probably where I should have started, is the systemic discrimination contention. I think that this is a place where almost every team is going to go as the negative on this topic because it is unavoidable. Every other argument that you, or every other article that you read on this topic mentions this in some way, shape, or form, says that plea bargaining in some way discriminates based on race, based on socioeconomic minority, based on other structural issues. And I think that there is just a whole host of plethora of evidence that it specifically structurally discriminates against Black people and people of color, and that this has really, really negative consequences in our society. And I think a lot of teams are going to go this route because it seems very capital T true on this topic. Now, I don't think it's maybe a slam dunk on this topic. I think that the affirmative has a bunch of things that they could say. I think that plea bargaining might be better than a trial, right? You have to think the affirmative is arguing for the status quo. So what does that change look like? So what does that jury look like? When we look at jury trials, there's a huge racial disparity among jurists. You have all white juries convicting Black defendants, and you have the historical data that just says that jury trials find Black people guilty at a higher rate than they find white people. And maybe that is not the place where we want to go instead of plea bargaining. Maybe that jury system would lead to more mass incarceration and more discrimination, right? Remember, the judge is in charge of the sentencing when a trial goes to a jury trial, so there could be discrimination at that level too, where different judges are known for being really harsh or always giving the maximum or treating women different than they treat men. And I think that a lot of different teams are going to go this route when trying to answer this argument, and that while you may think that this is a slam dunk, you're definitely going to have to account for how this operates in the debate because the alternatives might not be better. The reason behind this is a lot of the reasons why that systemic discrimination exists is in the criminal justice system, not just in plea bargaining. So the system itself is unchanged. The system of jury selection, the system of jails, the system of for-profit prisons, the bail system, the bond system, probation, policing, none of these things are necessarily changed with plea bargaining. So how does that really function in society for this argument? So while I think this is a really, really good argument for the negative, I think that there's definitely some things that you need to think about. The next scenario I think the negative can say relies around the increase in the prosecution's power. I'm not sure that this is a full-blown contention. It's more like a link or an internal link to different impacts, but the basic idea behind these style of contentions would be that the plea bargain shifts the power from the jury and the judge to the prosecutor, and that increase in prosecutor power is discretionary, is bad, and is not something that should be theirs. It has a bunch of bad consequences because the prosecutors don't like to do things in the open and don't like to do things in the courtroom, which requires due process and oversight of the judge and all sorts of different aspects to this. It definitely changes the way that our entire criminal justice system is set up. If you remember from part 1, when I had all of the diagrams about plea bargaining taking away the jury and giving sentencing power and changing how the verdict work and the judge not being as involved in the sentencing as before, a lot of these contentions are going to rely on those type of arguments that say that this increase in prosecutor power is bad because it leads to them abusing this power via overcharging people or just via not being reviewed by the Supreme Court or by any court, and that would be a way in which it would be unjust. I think that you will also have similar arguments that justify a negative contention for human rights based around this concept of the right to a fair trial. There's a lot of international human rights law that is based around this, that is exported from American democracy, but there's also the exportation of plea bargaining. I think that this could be used on the affirmative as well, but I think that the negative will say that a lot of other countries have adopted US-style plea bargaining because the US has wanted them to, so they have. So there's been a lot of international adoption of this US criminal justice system model of plea bargaining that is unjust. And if the United States were to no longer have plea bargaining or were to say it is unjust, then these countries would model in a similar fashion, and that would have benefits for the negative side in the debate. Just like the affirmative side said the rule of law, separation of powers contention, I think there's a really good argument for the negative here as well, how there's a constitutional basis for plea bargaining, but it seems kind of skeptical. These decisions in the past about how coercive plea bargaining has been allowed, there's a lot of articles that say that that violates concepts of the Constitution, but I think that there's probably a more strategic version of this that is more based around the legitimacy of the court system. I think a lot of this will have a great uniqueness scenario that says that the court is not viewed very healthily right now, and that plea bargaining is a way in which the court could revive itself and seem more legitimate, because right now the idea behind plea bargaining is what fuels the concept of the courts as corrupt or the judicial system as corrupt in the first place. Another just completely different style of contention that I think negative teams could employ are that the consequences that come with plea bargaining often involve you giving up your right to government assistance. So if you enter into a plea bargain in a lot of places, you may be ineligible for federal grants for education. You may be ineligible for SNAP or different food stamps programs or different just general benefit programs that as a condition for that plea agreement, you as the person accepting the plea, not you watching the video, will be encumbered by. And a lot of people don't realize this when they sign those plea agreements because they are just focused on the initial things. It's kind of like not reading a contract when you get a new job or sign an apartment lease. Everybody just kind of glosses it over. And when you look at the nitty-gritty details, there's a lot of things behind plea bargaining, like these ineligibility standards, that the negative can find some ground in on this topic. Another contention the negative will say will revolve around undocumented persons. It will say that different plea bargain agreements unknowingly or knowingly have the defendant agree to be deported as a condition for the plea agreement. There is a lot of evidence, a lot of history, a lot of cases where this has been the case, where a defendant unknowingly agrees to be deported as a condition for their plea bargained agreement. Now, there are also cases in some districts where the prosecutor works with the defendant to avoid deportation via the plea agreement, but I think that this is generally going to be the negative's ground in the debate. Another contention that the negative is going to say is due process. I think that this is similar to the prosecutorial power contention, where it's maybe more of a link, an internal link, than a whole scenario itself, but it generally relies on the idea that plea bargaining avoids this due process system that the courts allow for, and that it in fact not only avoids it, but it fast tracks it. So, things that get uncovered at trial, like police misconduct or evidence or all sorts of different aspects, are hidden from the defendant. So they need to go to trial in order for things like exculpatory evidence to come out. And that by agreeing to a plea bargain, you waive your right to even hear these facts, and that there are a lot of instances in which the prosecution is even hiding these from the defendant. And I think that this exemplifies the next contention, is just it avoids the jury trial. There are different aspects to due process, different aspects to agreeing to a plea bargain that I talked about in part 1, where you give up a bunch of constitutional rights. And by doing that, you maybe do not allow democracy to thrive in America, because that is how democracy, civic education works, is based around a jury of our peers to be charged for a crime. I think that the last area of negative contentions that you're going to see are going to revolve around cases of sexual assault, intimate partner violence, etc. There's a very good example of this with Brock Turner, where he agreed to a plea agreement where he essentially got off in a rape case. I think that a lot of negatives may use different value criterion framings here to say that the plea bargaining system allows toxic masculine males like Brock to get away with their crimes. I think that the idea behind plea bargaining is not retributive. So, the idea that you can drop charges down or people won't be punished for these crimes are a core reason why these style of contentions are going to be really popular on this topic. I think that they will probably go hand in hand with a value criterion that talks about the retributive idea of justice and that retribution is good and that we should not allow people who are guilty of really heinous evil crimes to be found guilty on lesser charges when they are guilty on all of the charges. So I think that this will be a way for negative teams to try to leverage their value criterion when arguing their contentions on this topic. For the final part of the video, we're going to switch gears and talk more about progressive style argumentation, starting with counterplans. The first counterplan that I expect to see is just abolish plea bargaining. I think that this is pretty basic. I'm not sure it's necessary given the wording of the topic, but I do expect to see it a lot where the negative is going to generate uniqueness or generate the ability to read their disadvantages by saying that we should abolish the institution of plea bargaining. I think that you will see teams read a less drastic version of this counterplan that will maintain some form of plea bargaining and sort of toe the middle line. I think that there will be a bunch of different versions of this, and there's a lot of literature on this, whether it be restructuring, reformatting, changing something about the plea bargaining system, curtailing specific instances that it's used that will be used by the negative in this debate. I also think that the affirmative will try to use some of this, which I'll talk about more when I get to topicality, but I think that this is negative counterplan ground on the topic. I think that there's going to be a specific subset of these maintaining some form of plea bargaining that's going to pick out of certain scenarios where plea bargaining is used. So they will say that plea bargaining is okay in non-capital cases, but it is unjust in instance of capital cases, of instances where the death penalty is used, of instances of sexual assault. I think that there are going to be a lot of ground for this in the debate. Not sure any of these counterplans are really competitive, but that's a whole different discussion. I think that another subset of counterplans that we will see on the topic is just changing some other different aspect of the criminal justice system. It will try to steal the affirmative's advantages via saying it solves via some other aspect of the criminal justice system, but the affirmative still links to these disadvantages or contentions that the negative has in the debate. Maybe they try policing reform, maybe they try prison reform, who knows what, but the basic idea there would be to change some other form of the criminal justice system rather than plea bargaining. I think that another type of counterplan that we will see are advantage and uniqueness counterplans. Generally, we don't see a lot of these, especially uniqueness counterplans in LD. I think we're going to see way more of these on this topic because the topic defends the status quo via the affirmative not having inherency and defending the status quo. I think you will see a lot of negative teams try to combat this by reading uniqueness counterplans. I think the final counterplan that you are going to see on this topic is a criticism of the word criminal justice system. I think that this is going to come in a lot of different flavors. Some of these counterplans or plan-inclusive counterplans are going to say the phrase criminal justice system is bad, the concept is bad. Some are going to criticize different particularities of this. So I talked about in the first video how a lot of people call it the criminal punishment system, and that justice is not a good way to think about this because everybody gets punished and it's not about justice. On the flip side, there are other criticisms about the label of criminal and why that is not something that society should be okay with. So I think that this criminal justice system word pick, whichever flavor you choose, is definitely a place that negative teams can go on this topic if they want to read counterplan style arguments. Moving on to topicality, I think there's a couple arguments that could be strategic on this topic. I think that the first one is going to be defining plea bargaining. There's going to be a heated debate as to whether or not plea bargaining can be coercive or not, and I think that these definitions are maybe not even going to seek to win a T debate, but rather seek to limit out a bunch of the affirmatives' offense in the debate, because if they win that T bargaining is not coercive, then the things that the affirmative says are unjust that have coerciveness in them are going to be things that they are no longer, allowed to or forced to defend as part of the topic. So I think that, this might not be seen as like a T you lose argument, but rather like a T majorly minimize the amount of offense that the affirmative can get in the debate. I think that there is a huge effects and extra T debate on this topic. I think that this is mainly going to be read against LARP teams on this topic, or teams that roleplay as policy debaters, where if you are going to say the United States should abolish plea bargaining, that is not the resolution. That's not the topic. That imposes so many additional things that are not in the resolution at all. And I think that there is a huge debate to be had here for the negative, that if this is how you choose to approach the topic, that's probably something that you could be punished with topicality in the debate. I think the flip side of that is that smart policy teams will not have to defend the instrumental action and then just defend the statement, and I think that might be a more strategic route. However, I think it's inevitable that a bunch of teams are going to read cases that say you should reform or you should abolish plea bargaining or something along those lines. I think that anyone who reads a court case, you'll see, the silly test case procedurals, things like that you've seen in the past, different sort of which way court justices vote, how is the decision, all sorts of different aspects to this. I also think, and it's not even written here, I think that the word is really important too. I think that there's two reasons why. First is that it forces the affirmative to defend the status quo. So that means that they can't defend the past or the present, but more so that it probably means that they can't say reform, because is means the status quo, and an affirmative that tried to reform plea bargaining to be just, to say that plea bargaining is just, would not be topical, because that would say is just in a future world, or could be rather than is. So I think that is definitely a place where you could read a topicality argument or three in the debate. The last thing, I think you're going to see this on every topic because of the way LD debaters like to argue things, but I think that T whole res has a really good foundation on this topic. I think that just the wording of the topic lends itself to this. I don't think that you can really defend the specific instances as well as you can on past topics. I also think that the word in is going to be used here to say that it has to be throughout. This is kind of like an old wonky policy thing, but I think that you will see this more also defined with the criminal justice system, saying that thing as a whole has to be upheld. So I think that there are a couple of really good topicality arguments that you could read on this topic. I think this topic has incredible ground for teams to read critical arguments on the negative. However, for the sake of this video, I'm going to try to keep it short because I'm pretty sure I could add at least an additional hour right now. Let's start with some specific critiques to this topic that I think are going to really apply. The first one of those is going to be abolition. I expect abolition to be the number one critique read on this topic. Traditionally, you'd hear CAP or Afro-Pes or settler colonialism. I think it's definitely abolition on this topic. Anytime that the criminal justice system is a matter of debate, this is a hot, heated subject, and I think that the way that this topic is worded, that it is no different. The basic premise behind this idea is that the criminal justice system, the institution of prisons, should be abolished, and that the affirmative, by upholding the criminal justice system and plea bargaining, is antithetical to abolition and actually allows the criminal justice system to further itself via mass incarceration. The negative in these debates would say that the affirmative is not even an act of reformism, that they just uphold the government. And I think that they will have an alternative that says that we should abolish prisons or the criminal justice system or the state and society as a whole, and that this is crucial ground that every affirmative team is going to need to think about how they are going to answer. I'm not going to spend any more time here. If you want to go to the 2020-2021 open evidence for the policy criminal justice reform topic, there's like 20 files that you can go through. This is going to be the number one critique that I expect even policy style teams to read, because it just inherently clashes with the topic. The second specific critique that I expect people to read on this topic are critiques that revolve around the legal system, whether that be different critiques of legalism, critical legal studies, critical race theory, or just generally critiquing the concept of normativity. I think that there will be a bunch of different critiques that rely upon using law as a neutral concept for everybody and how that is a bad conception for us to start with. I also think that there will be a lot of teams reading the biopower critique. There's a lot of evidence. I've talked about this in several sections of this video even, where the state gets a lot of power from plea bargaining, and that plea bargaining legitimizes a lot of increase in state power. And that is where this critique link ground will be grounded in. I also think that another critique that people will read, I guess it's more of a link or internal link rather than a whole scenario, but it's going to be arguments based around algorithmic violence. The basic idea behind this is that different sentencing guidelines, different plea bargains that people are given are based around different mathematical equations. These cases, these critiques will probably talk about mandatory minimums and how those function, and critique those and how they use a system of computerized violence to uphold how society functions, rather than looking at the specific details of every specific case and deciding what should be done in that specific instance. So these are some critiques that I think may be unique to this topic. Now I want to switch a little bit and talk about some critiques that we see on most topics. Afro-pessimism, settler colonialism, capitalism, we see these critiques on every topic, and this topic is going to be no different. For settler colonialism, there's a lot of literature that's going to be very similar to the types of critical legal studies critiques that I just talked about, that's going to critique the idea of the U.S. legal system as a settler colonial institution. The capitalism critique will have a bunch of different angles, but I assume a lot of them will revolve around the idea of mass incarceration and the prison industrial complex. Afro-pessimism is going to say, what has the law done for Black people? Is this bargain really something that is beneficial for Black people? I think that if you want to say any of these arguments, there's a whole host of ground here. You don't really need to hear it from me, and you can just go straight into this. I think that the thing that you do want to hear, though, is that I think that every team that reads a critique on this topic needs to think about how their alternative functions in the debate, because the affirmative is upholding the status quo. So that means if they don't policyify their affirmative to where they're like abolishing plea bargaining, all they are saying is a general statement is just. So if you have an alternative that does something, the permutation is probably going to resolve that. So you need to think about, how are you going to be able to get competition in a perm debate where the affirmative is just upholding this general is just statement, because your alternative is probably going to rely on changing the world, and smart affirmative teams are going to use that to try to spin a permutation in their favor. And I think that the affirmative is in a really good spot here on this topic. So even if you're going to read these arguments and you're like, oh, Scott, you didn't talk anything about my thing that I wanted to say, you're probably better off reading that literature anyway, but go into it thinking, how is my alternative going to function? Because the way that links work, the way alternatives work versus these affirmatives are very different. I would go back to where I started the policy debate Aff discussions with talking about how there's no fiat, there's no solvency, there's no actor, there's no inherency, and think about all of those things when you are constructing your critiques, because I think that that might be more important than the substance of the critique itself. Final slide, critical affirmatives. Unlike the critiques part of this lecture, I really don't think that critical affirmatives are that great on this topic, especially if your affirmative is in the direction of the topic. I think that the reason for this is that the affirmative is upholding the status quo rather than changing anything. I think that maybe you could read like Warren or an Afro-pessimism argument that says that, you should give up hope in change, and that reforming anything, that abolishing plea bargaining, that doing any of this criminal justice reform is bad, is a false hope, it legitimizes the state, and we should just keep the world the way it is right now. I'm not sure that's the angle that I would go with on the topic, but I'm not sure that there's a lot of critical affirmative ground other than that, because there's just not a lot of reasons why plea bargaining is just from a critical perspective. I do think that you're going to see people just outright read anti-topical affirmatives, where they are going to read these critiques as affirmatives and just have the framework debate. So I think the abolition affirmative, the capitalism affirmative, the critical legal studies affirmatives, all of these affirmatives are going to be read as just like critique affs, and they're just going to have the framework debate. They'll have the T debate that says they can abolish, they can reform, they can do different things, or just that there's no negative ground for this, so that they should be allowed to do it on the affirmative. But I think that this topic, I expect a lot more critical affs that are antithetical to the topic or not topical, rather than trying to be soft left or skirt the line of the topic, because I just don't think there's a lot of ground. I don't think there's a lot of people who defend those style of critical arguments in the debate. So that's it. I hope you found this video and part 1 helpful in prepping for the September-October plea bargaining topic, and look forward to seeing you in an upcoming video. Bye!